Afternoon, I am Shiela Olguera and I am continuing the number 1 exceptions to the general rule. And those who were practically locked out or had no alternative but to declare a strike to render aid and protection to themselves and their unlawfully dismissed companions because of the employer's improper and oppressive conduct, are entitled to back wages, the first from the day of their unlawful discharge, and the second from the day they strike. Number 2, strike duration pay is also due to strikers who offered to return to work but the employer refused to reinstate them or imposed upon their reinstatement new conditions that discriminated for their union membership or activities. In such a case, however, three conditions must be satisfied, namely, that the strike was legal, the offer to return to work was unconditional, and the strikers were refused reinstatement. Number 3, another possible exception is where in the agreement concluded by the parties to settle the strike dispute, the employer undertakes to pay the strikers their wages during the strike period in consideration of their ending the strike. Number 8, liability for damages. When the strike is lawful, both as to purpose, compliance with legal requirements, and the means employed in conducting it, neither the union nor its members may be held liable for any damage that any person may suffer as a result thereof. Qui jure suo otitur neminem laedit. He who acts in the lawful exercise of his right injures no one. The resulting damage is damnum absque injuria. A labor organization, however, may be held liable for damages if it declared a strike to attain unlawful ends, or try to attain legitimate objectives through unlawful means. That is, if the strike is illegal, but in order to hold the union liable for the unlawful acts of individuals, officers, members, or agents, there must be proof of actual authorization or ratification of such acts after actual knowledge thereof. Or it must be shown that the conditions for collective liability are present. That is to say, that the strike was conducted with widespread and pervasive use of violence, consistently and deliberately resorted to as a matter of policy. In the case of individual strikers, as earlier adverted to, they are responsible for their own illegal acts. The doctrine of vicarious liability has long ceased to apply. For such acts, they may be made liable for damages they may have caused, aside from suffering loss of employment status. In order that damages may be recovered, the best evidence obtainable by the injured party must be presented. Actual or compensatory damages cannot be presumed, but must be duly proved, and proved with a reasonable degree of certainty. However, were the illegal strike dragged on for 50 days, paralyzing the company's operations, there is no room for doubt that some species of injury was caused to the company. In the absence of competent proof of the actual damages suffered, the company is entitled to nominal damages, which, as the law says, is adjudicated in order that a right of the plaintiff which has been violated or invaded by the defendant may be vindicated and recognized and for any loss suffered. In this case, the amount of 300,000 pesos was considered a just and reasonable award under the circumstances. Number 9, criminal liability. The strikers who committed illegal acts during the strike may also be criminally prosecuted for such acts. The penalty for violation of any of the provisions of Article 279, including any act of violence, coercion or intimidation, or obstruction of the free ingress to and egress from the employer's premises for lawful purposes, or obstruction of public thoroughfares, committed by any person in picketing is provided in Article 287. Of course, if the violence, etc., resulted in a more serious offense under the revised penal code, the penalty provided by the latter if the offender is convicted thereunder shall apply. In the consolidated cases of Sarmiento and Asian Transmission Corporation, earlier cited, a question was raised as to whether the criminal prosecution of certain persons involved in the subject strike could validly be restrained, pending determination of the legality of the strike. The answer of the Supreme Court was that while, as a general rule, the prosecution of criminal offenses is not subject to junction, the suspension of proceedings in the criminal complaints filed in court was justified on the ground of prematurity because the acts complained of were connected with the compulsory arbitration proceedings pending in the NLRC. Such suspension was deemed to be in pursuance of the policy embodied in Circular Number 15, Series of 1982, and Circular Number 9, Series of 1986, issued by the Ministry, now Department of Justice, in connection with the implementation of BP Number 227. These circulars required government prosecutors to first secure the clearance of the Ministry, now Department of Labor and Employment and/or the Office of the President, before taking cognizance of complaints for preliminary investigation and the filing in court of the corresponding informations of cases arising out of or related to a labor dispute, including allegations of violence, coercion, physical injuries, assault upon a person in authority, and other similar acts of intimidation, obstructing of free ingress to and egress from a factory or place, or operation of the machines of such factory, or the employer's premises. No such clearance was obtained in connection with the complaints in the case referred to above. In the case of People v. Barba, 29 SCRA 662, more than 100 strikers against Red v. Coconut Product were charged with illegal detention on the basis of the complaints of two officials of the said company to the effect that they could not leave the company compound.